Hi everyone, welcome to Impact Academy. So today let us continue with Indian Polity. So today let us look at governor, governor, chief minister, etc. So we are talking about the executive of the states. So the governor of a state is appointed by the president and holds his office at the pleasure of the president. So we have already seen in the case of president, if you want to remove the president, there needs to be a impeachment procedure. Okay, we have seen all that resolution passed by both houses and all those things we have seen. So, but governor is not like that. Governor of a state is appointed by the president, and he holds his office as the pleasure of the president. So, qualifications for the post of governor are he should be a citizen of India, should be over 35 years of age. Okay, so president, vice president, and governor 35 years. For MLA 25, MLC 30. Okay, chief minister 30. Okay, remember all those things. So must not hold other office of profit and should not be a member of the legislature of the union or any state. So just like the president, he should not be a MP, right? He is a part of the parliament, but he is not a member of the parliament. So similarly, governor, he should not be a member of the legislature or of any union or basically he should not be an MLA. Okay, and many commissions like Sarkaria commissions etc. have opened that the governor has to be preferably be someone who is from outside the state, not someone belonging to the particular state. Next, if a member of a legislature is appointed as governor, he ceases to be a member immediately upon such appointment. So once he becomes governor, he is no longer MLA. That normal term of governor is 5 years. Okay, the normal term is 5 years, but there is no fixed term. It can be terminated by dismissal or resignation. So when we talk about governor, it usually comes at article 153. So part 6 deals with the state government. Okay, so within that the executive starts from 153. And these days, more and more questions are being asked from the governor. So, governor is more important. So, just go through all these things. You see, in the case of president, it is Article 72, right? 72 deals with the power of the president to grant pardons. So, 161. Okay, 72, 161. You have to correlate. 72, you reduce 1 from 7, it becomes 6. And the 2, you place 1 here and 1 here. So, try to remember like that. So, all these are, what you say, whatever is related to the parliament is somewhat related to the state government also. So if the president, president is we've seen 52, right? So governor is 153. So like that, there will be some relation. Okay, try to link and remember. So especially when we are preparing for group 2 or anything, even these articles are very important. Frequently, such because there are 75 questions, such articles are also asked. Anyway, this 161 is important. Power of governor to grant pardons. So 163 is basically talking about Council of Ministers to aid and advise the governors and Advocate General. Okay, 165. Next we have 200 is also usually frequently asked. So is 200 assent to bills. Okay, this is also frequently asked. And definition of money bills. This is with regard to the state government. Okay, 199. There in the Parliament we have seen Article 110. Okay, 200 is assent to bill. That is the governor has to give the assent to the bill which is passed by the state legislature. There we have seen 112 is the annual financial statement, that is budget, right? Here in state government, it is 202. There it is 112, it is 202. Fine. And so all that is fine. So 156 deals about the dismissal. Okay, 156 deals about the dismissal. Term of the office of governor. Okay, so it is fixed term and qualifications for appointment, conditions, oath or affirmation, discharge, etc. etc. So there is no bar to a person being appointed governor more than once. So any number of times he can be governor and he can be governor for more than one state. Why an appointed governor? Because it would save the country from the evil consequences of still and the election run on personal issues. So basically a governor is more like a guardian of the constitution. He looks after the whether the constitution is being adhered to in the state or not. So if the governor is elected by direct vote, then he might consider himself superior to the chief minister, leading to friction between the two. So governor is not elected directly, just like the president. Okay, so if president is elected indirectly. So in the case of governor, he is appointed directly by president. Okay, he's not even elected indirectly. So the expenses involved in the elaborate machinery of election would not match the powers of the governor. Okay, a second-rate man of the party may get elected as governor. So, through an appointed governor, the union government can maintain its control over the states. The method of election may encourage separatist tendencies. So, these are the reasons why we don't go for election for the governor. And a person who has what you say, who is has a certain exposure to administration, etc., who is having certain background, academic background, etc., who has already done a lot of who has been in public service for a long time. Usually, such a person is appointed as the governor. That's why we see frequently retired IAS officers, okay, retired Supreme Court judges, etc. They're often given positions as governors. So, if you look at the powers of the governor has no diplomatic or military powers like that of the president. So, president is head of the defense forces, right? But governor is not like that. But he has executive, legislative, and judicial powers analogous to that of the president. That means similar to it. If you talk of the executive, the governor has the power to appoint the council of ministers, including the chief minister, advocate general, and the member of state public service commissions also. So, APPC chairman, etc. Okay. So, this you have to remember, because if you talk about the Chief Justice of India, he is appointed by the president. I mean, the oath is administered by the president. But in the case of Chief Justice of High Court, the oath is not administered by the governor. It is administered by the president only. So don't try to link everything. Try to have clarity. Okay. So the governor appoints council of ministers, advocate general, and members of the state public service commission. He does not appoint chief justice or judges of high court, because president does so in the case of Supreme Court, but governor does not in the case of high court. The ministers as well as the advocate general hold office during the pleasure of the governor. So even the advocate general and the ministers, they hold office during the pleasure of the governor. But the members of the State Public Service Commission can be removed only by the president on the report of the Supreme Court, and in some cases on the happening of certain disqualification. Okay, this is Article 317. So when you talk about public service commissions, usually comes at 312, 314, like that. So All India Service is 312. Okay, and All India Service is 312. So public service commissions of union and for the states. So when it comes to states, it is 315. So All India Services, IAS, IPS, and all those things, we are talking about Article 312. And when it comes to UPSC, APPSC, etc., that is Article 315. Okay. Removal and suspension of a member of a public service commission, it is 317. Okay. So 317. Removal is 317. The governor has no power to appoint judges of the state high court. So just now I told, right, the governor does not appoint the judges of high court, but he is entitled to be consulted by the president in the matter. But in the case of Supreme Court, it is the president who appoints the judges, of course, on the consultation of the cabinet, but it's the president. So similarly, in the state government, it is not the governor. Even high court judges and chief justice are appointed by the president himself. Like the president, the governor has the power to nominate members of the Anglo-Indian community to the legislative assembly. So in the case of president, he can nominate two persons of the Anglo-Indian community to the Lok Sabha. In the case of governor, he can nominate only one person from the Anglo-Indian community to the legislative assembly. Remember that. Okay, president 2, governor 1. So to the legislative council, the governor can nominate persons having special knowledge or practice of experience of literature, science, art, and social service. That is common for both the parliament and the what you say Rajya Sabha and the council. Only thing extra is this cooperatives, because cooperative movements are more prominent in the states. The states benefit more from these cooperatives. Okay, so cooperative movement is not included in the corresponding list for the Rajya Sabha. So it is a special inclusion for the legislative council. So those are the executive powers of the governor. So when it comes to legislative powers, governor is a part of the state legislature, and he has the right of addressing and sending messages and of summoning, proroguing, and resolving the state assembly. So just like how we've seen the case of president, okay, the governor can also summon, prorogue, and dissolve. And president is a part of the parliament. So governor is a part of the state legislature. So this can confuse you in the exam. Okay, so suddenly they might say that governor is not a part of the state legislature. Okay, so you may think that yes, a governor is appointed by the central government, and the governor is coming from outside. He is not involved in the politics, so he is not part of the state legislature. So you can get confused like that. But actually, the president is part of the parliament, and the governor is also part of the state legislature, and he has the right of addressing and sending messages and summoning, proroguing, and dissolving. So every time there is a new session, he summons it. Okay, and he gives the first address. He gives assent to all the bills and to vote of thanks, everything. So when it comes to judicial power, the governor has to power grant pardons 161. In the case of president, it is 72. In the case of governor, it is 167. We've also seen that governor cannot deal with death pardons. Okay, and he also cannot deal with court martials. Court martial is punishments given to the defense personnel. President has powers with regard to court martial and also death pardons. But governor cannot grant pardons for death sentence. Everything else he can do. Normal pardons, reprieve, respite, remission, all those things he can do. So the governor has no emergency powers to counter external aggression or armed rebellion. So when it comes to emergency, national emergency, state emergency, all those things, those are the powers of the president, parliament, etc. Okay, state legislative governors don't have those powers. He has the power to report to the president if the government of the state cannot be carried in accordance to the constitution. So this is the what is the president's rule? Article 356 is very prominent, right? Everybody knows this. It's called the president rule. Okay, so emergency provisions, if you look at it, Part 18 deals with the emergency provisions. 352 is proclamation of emergency, very important. And all these things are important. Again, 356 is president's rule. It is called as the president's rule. Provision in case of failure of constitutional machinery in states. Suppose elections are being rigged or proper procedure is not followed in the assembly. Okay, Lok Sabha is passing the bill without any, I mean, anything that is not happening according to the constitution, then the governor can declare it as unconstitutional, and he can report to the president saying that the government of the state cannot be carried on accordance with the constitution. Then the president rule will be imposed. Okay, president rule will be imposed, and then the governor will become all powerful. The governor will rule the state in the name of the president. So several times in the past, president's rule has been frequently imposed. Even in Andhra Pradesh, it has been imposed many times. And even while making the constitution, while framing the constitution, Dr. B.R. Ambedkar also opined that president's rule is an extraordinary measure and should not be referred to just like that. Okay, but in reality, it has been several times president rule has been imposed. So that is about the governor. So if you look at the chief minister and the state council of ministers. So governor is article 153, right? We have seen article 153. Okay, article 153 is governor. So article 153 is governor, and we have seen 161 is to grant pardons, etc. Disqualification. There is no such thing as impeachment. So we've seen all these things, and 163 is Council of Ministers to aid and advise the governor, and 164 is other provision as to ministers. So usually when you talk about chief minister, 163 and 164 are the articles which are related to the chief minister. So chief minister is the head of the state council of ministers. The chief minister is appointed by the governor. The other ministers are appointed by the governor on advice of the chief minister. So basically all the ministers are appointed by the governor. Basically the oath is given by the governor. So any person may be appointed as a minister, but he must become a member of the legislature within 6 months of such appointment. So that is why sometimes we see that CM candidates lose in the election, but still they become a chief minister, right? So that is because anyone can be appointed as a minister, provided within 6 months they have to become MLA or MLC or whatever accordingly. So the Council of Ministers is collectively responsible to the Legislative Assembly. So this is one thing which is a part of Indian democracy, is collective responsibility, not individual responsibility. Okay, so that means once you have a cabinet of ministers, you have a irrigation minister, education minister, they are all collectively responsible. Okay, you cannot education minister cannot say that I don't know what is happening in the irrigation department, I don't know what is happening in the commerce industry, or I mean, so if you are a minister, you are collectively responsible. Everyone is responsible for the public. So the relation between governor and his ministers is similar to that of president and his ministers. Okay. Next, discretionary functions of the governor. the functions which are specially required by the constitution to be exercised by the governor in his discretion are: the governor of Assam can determine the amount payable by the state of Assam to the district council as royalty accruing from licenses for minerals. Where a governor is appointed administrator of an adjoining union territory, he can function as such administrator independently of his council of ministers. So governors will also act as the administrators of union territories. The president may direct that the governor of Maharashtra or Gujarat shall have a special responsibility for taking steps for the development of the Vidarbha and Saurashtra. So when it comes to Maharashtra and Gujarat, because there are disputed places, this Vidarbha and Saurashtra, the governor has to take special responsibility for developing these areas. The governor of Nagaland has similar special responsibility with respect to law and order in that state. So even in Nagaland, we have seen that there is a ongoing what you say protest for separate Nagaland, right? So, Governor of Manipur also has special responsibility to secure the proper functioning of the Committee of Legislative Assembly, consisting of members elected from hill areas of the state. So, Manipur also is a border state. A lot of even we have this Armed Forces Special Powers Act and all this going on. So, there's a lot of commotion going on there. So even Manipur governor has special responsibility. Governor of Sikkim has responsibility for peace and equitable arrangement for ensuring social and economic development. Governor has the power to dismiss an individual minister at any time. So recently we've seen in the case of Kerala, right? Kerala governor, Mr. Arif Mohammad Arif Khan, uh, he gave a statement saying that a particular minister has lost the confidence of the governor. So basically, till now, usually it never used to happen like that. Governors used to only act on the advice of the cabinet. So, but a governor also has the power to dismiss an individual minister. The governor can dismiss a council of ministers or the chief ministers only when the council of ministers has lost confidence of the legislative assembly. So just like that, he cannot do. He has to. There has to be a no confidence motion, or clearly it is visible that the Council of Ministers has lost the confidence of the Legislative Assembly. Suppose there are 100 MLS and it is clearly seen that 50 to 60 assembly MLS have left, okay, joined another party, then there is no more majority, okay, and the governor does not think fit to dissolve the assembly. But when there is a clear majority, the governor usually what happens is he clearly has to invite that particular head of that party to form the government, okay. So we've seen state legislature already. So let us look at Advocate General also, because Advocate General is closely related. Advocate General at the center or the state is closely related to the legislature also. He participates in the proceedings. So each state has an Advocate General, an official corresponding to the Attorney General of India and having similar functions of the state. So we are talking about Attorney General of India, similar functions. So at the central level you have Attorney General, at the state level you have Advocate General. He is appointed by the governor of the state and holds office during the pleasure of the governor. Next, only person who is qualified to be a judge of a high court can be appointed as Advocate General. So governor can be anyone, but Advocate General has to be qualified to be a judge of a high court. He receives such remuneration as the governor may determine. He has the right to speak and take part in the proceedings of, but no right to vote in the House of Legislature of the state. So he can go and speak in the assembly also. He can take part in the proceedings, but he cannot vote in the House. Fine. So we have seen about Governor, Chief Minister, Council of Ministers, and Advocate General. Okay. So we'll continue in the next class.